Section 184. Disclosure of interest by director. Board of Director can attend the board of meeting, but if he has any interest, what do you mean by interest? He has some influence in the transactions, that has to be checked. Before that, he has to disclose his interest before the meeting and cannot participate in the meeting. Example, company Y entered into a contract with the company Z with a paid up capital of rupees 50 lakhs. The director of Y director of Y company is holding equity shares of the nominal value of rupees 50,000 in Z company. The director of a Y company did not disclose his interest at the board meeting. Director of Y did not disclose his interest at the board meeting under section 184. So we have to know what is interest. So is this having a equity shares in the company, in other company by the director which has the contract? Is it a interest? That we have to study in the section 184, disclosure of interest by directors. Section 184 of the Companies Act 2013 provides for disclosure of interest by directors. So disclosure should be done by the director. Who has to disclose? Directors who has interest. Section 184 is applicable on all directors of the company and all the types of companies. So it is applicable to all companies and all types of director. Even for the private company, this provision is applicable, but directors of the private company can attend and participate in board meeting after disclosure of interest. Can participate and vote also for the private company. When to disclose, every director shall, at the first meeting of the board in which he participates as a director. So when to disclose, first meeting, as he participates as a director. Thereafter, at the first meeting of the board in every financial year, and thereafter the first meeting of the board in every financial year. Thereafter, first meeting of every financial year on 4/2000, whichever first meeting comes, that time has to be disclosed. Third, whenever there is a change in the disclosure already made, then at the first board meeting held after such change, whenever there is any change in the disclosures already made, then at the first board meeting held after such change. So whenever there is a change, for example, X company, Y company having 50 lakhs of shares capital, directors of X company have nominal value of 3 lakh. So this will be considered as interest, so he cannot participate. This director of X limited cannot participate in this if there is any contract between the X limited and the Y limited, because one of the condition is 2% of other company having share capital. Here it comes 2 lakh 3 lakh divided by 50 lakh, it will come 6%. So it will be more than the 2%. It is known as interested director. He cannot participate. Director of X, this particular director cannot participate in this board meeting. But whenever this changes, he withdrawn the capital, redeem the shares in Y limited, there is a change and redeemed 2,50,000. Now the nominal value is only 50,000. Now he can participate in the board meeting. There is a change, so this has to be informed to the company. This has to be disclosed. General disclosure. Every director shall disclose his concern or interest in any company or companies or bodies, corporate firms or other association of individuals, which shall include the shareholding in such manner as prescribed in Rule of the Companies Rules 2014. The said rule prescribes that the director shall disclose his concern or interest by giving notice in writing, MVP 1. So every director shall disclose his concern or interest in a company. So disclosure mbp 1. Specific disclosure. So that is a general disclosure. Now specific disclosure. Whenever any director of a company who is in any way, whether directly or indirectly concerned or interested in a contract or arrangement or a proposed contract or a proposed arrangement entered into or to be entered into, shall disclose the nature of his concern or interest at the meeting of the board in which the contract or arrangement is discussed, and shall not participate in such meeting. Following are circumstances where the disclosure is necessary. Whenever any director of the company who is in any way, whether directly or indirectly, concerned or interested in a contract or arrangement or a proposed contract or a proposed arrangement entered into or to be entered into with a body corporate, which shall which such director or such director in association with any other director holds more than 2% shareholding of that body corporate, or is a promoter, manager, chief executive officer of that body corporate. So here we'll give that example only. X company, Y company. So he cannot be, there is a contract between the X company, Y company. Here are the directors. If they hold 1, 2, 3 more than 2% shareholding in a body corporate, this is a body corporate. So if there is a more than 2% shareholding, it will be known as interested directors or promoter, manager, chief executive officer. Manager, promoter, executor of that body corporate. With the firm or other entity in which such director is a partner, owner, or a member, as the case may be. X company have a contract with the arrangement with the Y firm or a Y sole proprietorship or a Y and HUF. In this partner, this particular anyone, partner, owner, or a member, so it will be known as interested, should be disclosed. However, where any director who is not so concerned or interested at the time of entering into such contract or arrangement, he shall, if he becomes concerned or interested after the contract or arrangement is entered into, disclose his concern or interest forth with when he becomes concerned or interested, or at first meeting of the board held after he becomes so concerned or interested. That is logical and common sense. In case of a private company, section 184 subsection 2 shall apply, with the exception that the interested director may participate in a such meeting after disclosure of his interest, that is as per notification. Whereas with the respected companies covered under section 8, the section 184 subsection 2 shall apply only if the transaction with the reference to the section 188 on the basis of the terms and conditions of the contract or arrangement exceeds 1 lakh rupees. So section 184 subsection 2, there is a one notification with regard to private company, so they can participate in the board meeting and also vote only after disclosure of his interest. So in case of section 8 company, terms and conditions, terms and conditions of the contract are not if exceeds rupees 1 lakh as per section 188 related party, then section 184 subsection 2 will be applicable. Consequences of non-disclosure: voidable at the option of the company. Voidable at the option of the company. So company can accept the contract or arrangement, or can reject the contract or agreement. A contract or arrangement entered into by the company without disclosing or with participation by a director who is concerned or interested in any way, directly or indirectly, in the contract or arrangement shall be voidable at the option of the company. Penalty: if a director of the company contravenes the provisions of subsection 1 or subsection 2 of the section 184, such director shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 50,000. Now this is amended, it will be extended to 1 lakh. So penalty: if a director contravenes this section, fine up to rupees 1 lakh, extended to 1 year, fine up to 1 lakh, and imprisonment for a term which may extend to 1 year. Imprisonment for a term which may extend to 1 year. So if a director of the company contravenes the provision of such, directors shall be punishable with the imprisonment for a term which may extend to 1 year, or with fine which may extend to rupees 1 lakh, or with both. So which may extend to 1 lakh, this is not updated. there is a amendment with regard to this. 50,000 is removed. No restriction on directors. Nothing in section 184 shall be taken to prejudice to the operation of any rule or rule of law restricting a director of a company from having any concern or interest in any contract or arrangement with the company. So company X company, Y company, they can have arrangement or a contracts where director or of X company have any interest. There is a no limitation, no restriction on the directors, no restriction on the directors. But but he cannot attend the board meeting, he cannot participate the board meeting. He has to disclose his interest. That is the provision, disclose interest as per section 184. Exception. Section 184 shall not apply to any contract or arrangement entered into or by to be entered into between two companies where any of the directors of the one company or two or more of them together holds or hold not more than 2% of the paid up share capital in the other company. So the first example I gave, this example, company Y, there may be set of directors A, B, C. Together they have holding nominal value of 50,000, paid up capital 50 lakh is there. So up to 2% there is a exception. When the more than 2% goes, then they will be known as a interested director. Here what is the percentage? 50,000 divided by 5 lakh, 50 lakh, it will come 1%. So here did not disclose his interest. Director need not to disclose interest because it is exception is there, because it is less than 2%, or you can say not more than 2% of paid up share capital. That is what exception. Section 194 shall not apply to any contract or arrangement entered into or to be entered into between two companies where any of the directors of the one company or two or more of them together holds or hold not more than 2% of paid up share capital in the other company. Example, company Y entered into contract with the Z, paid up capital 50 lakh rupees. The Y company holding equity shares nominal value of rupees 50,000 in Z Limited. The director of Y holding nominal 50,000. This paid up capital, this is not of the Y company, this is of the Z company. That has to be very important. You cannot confuse this paid up capital of Z company, not of the Y company. The director of Y company did not disclose his interest at the board meeting. Is this director liable to for this act? No. As per section 184 subsection 2 of the Companies Act 2013, disclosure of interest by the director do not apply to any contract or arrangement within two companies where any of the directors of the one company or two or more of them together hold not more than 2% of the paid up share capital in other company. In the present case, the shareholding of the Y company in the company Z is less than 2%, that is 1%. So the director of a company is not liable. So this is with regard to the section 184, disclosure of interest by director. Disclose his interest, cannot participate in board meeting, except private company. After disclosure of interest, he can participate and vote when first meeting he has